So where are your parents?
I don't have a dad. He passed away when I was young, and my mom lives in Mexico.
Okay, so who's your support system here?
My tia.
You can't smoke marijuana on probation.
Yeah.
Those are the rules. You can't drink alcohol on probation, even if you're in your home. Those are the rules.
So nothing.
No, you're not allowed to. And people, oh, Judge Boyd, why are you being so hard? That's the law.
Yeah.
5374, State of Texas versus Juan Eduardo Caballeros. Could I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense?
Nick Aguilar on behalf of the Honorable Mr. Caleros.
Oh, is it Caleros?
Calleros.
See, I'm just adding extra syllables to your name. How do you pronounce it?
Calleros, so Call, like
Caballeros?
Calleros.
All right. Counsel, have you received all of the discovery?
At your point, yes, Judge.
And did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Calleros, did you review the application for deferred adjudication with
Yes,
your
ma'am.
attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
I believe so, Your Honor.
We're going forward on count one, Judge.
All right. Mr. Calleros, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Did you understand in the indictment? Oh, I'm sorry, you all are proceeding on count one?
Waiving count two, Your Honor.
Okay. Any objections to the waiver of count two?
No, Your
All right, in count one, you're charged with the offense of possession with intent to deliver a controlled substance, penalty group 2, 1 grams to 4 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
You have to make sure you keep your voice up, okay?
Okay. My bad.
So the court reporter can hear.
Okay.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
He has a rational as well as a factual understanding of the charges against him.
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Calleros, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
All right, did you review the plea bargain page with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one. There's a $2,000 fine. State is recommending deferred adjudication. This is the run concurrent with County Court 9 cause number 699437. They're taking in consideration 658-757, JN 215-9813, and there's to be restitution for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you understand by signing it, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
And did you sign beneath that paragraph twice?
Yes.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation and 150 hours of community service restitution. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offense as charged in count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right, state any evidence.
Be contained in exhibit one and attachments, Your Honor.
Judge, we've had the opportunity to review those exhibits and have no objection.
All right, state you may be excused.
Thank you, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports and laboratory reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court would defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Judge, if you would consider proceeding with sentencing, we do know there's a TAP evaluation and he has no problem following any recommendations that they may come up with.
All right. Anything you wish to say on behalf of your client?
Judge, you read the report, he accepted responsibility at the traffic stop, he made an admission. Today is our first appearance in court. Prosecutors made a very fair offer of deferred, and he did not waste any time saying that he would like to take it, no dragging our feet out. He would like you to consider following up with Morgan.
All right. How far did you go in school?
I graduated.
All right. So what are you doing with your life other than speeding?
I prep
Mhm.
Italian restaurant on Alamo Heights, by the way.
Oh, what's the name of the restaurant?
Sorrento's.
Sorrento's. I don't think I've ever been there.
Oh, yeah.
But is it very expensive?
It's like Olive Garden kind of prices.
Oh, you know what? I think I've been there before.
It's better than Olive Garden.
Yeah, it's better than Olive Garden.
Okay.
We have.
All right,
peaches and
hey, we're not gonna disparage anybody in here. I mean, because free bread, sticks and salad, that's something that you have to throw in the mix.
Although that price has even gone up.
Yeah, it's like the cheddar biscuits at Red Lobster. I mean, you can say what you will, but their cheddar biscuits are great. Do you have any children?
One on the way,
You guys
actually.
have one on the way, Judge.
Okay. So what are your plans for employment? Are you gonna always work there? What were you planning on doing?
Well, I've been thinking about going out of town for construction, just to, stay clean, get away from all this.
Okay.
The opportunity that he has may require him to travel out of state
Okay,
as far as Florida.
all right. And if you're drug tested today?
Would I come out clean? Yeah,
Are you clean or doing?
right now I'm 30,
All right, so what are you dirty for?
just weed.
All right, how long you been smoking weed?
Since high school, but I mean, I'm not, like, since I got older, I haven't really been smoking a lot, just like here and then.
All right, what does that mean?
How often? When was the last time you smoked?
Last week.
All right, so here's the thing. You can't smoke marijuana on probation.
Yeah.
Those are the rules. You can't drink alcohol on probation, even if you're in your home. Those are the rules.
So nothing, okay.
No, you're not allowed to. And people, oh, Judge Boyd, why are you being so hard? That's the law,
Yeah. Mhm.
right? So you're not allowed to do marijuana. If there's some issue where there's a mental health issue, and that's the reason maybe you're using it, then you need to let probation know, and we'll have you see a doctor. You understand? So where are your parents?
I don't have a dad. He passed away when I was young, and my mom lives in Mexico.
Okay, so who's your support system here?
My tia.
Yeah, uncle or aunt? I don't know.
Tina is an aunt.
Huh?
Come
Yeah,
on,
because-
I know that little Spanish.
But there was a lawyer in our office group that kept calling Johnny Cisneros Tia. I thought that meant uncle.
Maybe he was saying Tio. I don't know if there's a difference, but what is an uncle in Spanish?
Tio. Yeah.
That's what he was probably saying.
Well, I thought that's what he was saying.
All right. This is what, do you want to speak with regards to the length of probation time?
Judge, One did ask about the length, and we discussed the possibility of an early term if he complied early on and got everything done, the community service, patches, UAs. We did consider, we were hoping he would consider an early termination, maybe about the 2-year part. 2-year
Okay.
mark.
All right, so it's gonna be 5 years deferred adjudication. There'll be a $2,000 fine that will be probated. There's gonna be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Ms. Abrams, if you'll make sure that they test for levels, your levels with the marijuana needs to start going down. You understand?
Yes, ma'am.
And I do require that probation do field visits. Possession of marijuana is not legal in Texas. You understand?
Yes, ma'am.
There's going to be field visits 1 time per month for 6 months. Then at probation's discretion. And who do you live with?
Well, since I had a baby on the way with my baby mama, she heard the
Let's
apartment.
just say the mother of your
Oh.
future child.
Okay, yeah. that-
Okay. Yes.
Yeah, I got an apartment. It's under her name, but I pay for it.
Okay.
So,
All right. Don't be bringing any drama to her doorstep, because let me just tell you, she has decided to make you her star
mhm.
and she wants you in her life. She's decided to have a child with you, and you've brought this baggage with her already, which is this case. So you're gonna have to change your ways. Don't bring drama to her doorstep. Don't have drugs at her house. Don't do any of that, because she's trusting you. And now that you have a baby on the way, everything that you do from here on out, you need to do it so your child will be glad to tell children at school, well, this is my dad. You
Mhm.
understand?
Yes, ma'am.
Do not be a disappointment.
Mhm.
Okay? All right. So then we're going to do take in consideration 658, 757, JN 215, 9813. This will run concurrent with 699, 437. There's going to be 150 hours community service restitution. I'm going to order that you do parenting classes. Once you've completed parenting classes, the community service hours will be deemed satisfied. And we can do a TAP evaluation out of custody. Probation, if TAP recommends inpatient treatment, we'll start him with intensive outpatient treatment. There's to be restitution to SAPD for drug testing. Counsel, if you think that amount is too high, you can come back to the court and we can have a restitution hearing for that.
Certainly.
Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, to be successful in this court, communication is key.
Okay.
I know maybe other courts do things differently, but in here, if you feel like you're going to use marijuana, pick up the phone, call your probation officer, tell them, hey, I really feel like I'm going to use. And you know what they're going to do? They're probably going to tell you, this is where you need to go. Go to an AA meeting, go to an NA meeting. If you feel as though they're not addressing your issues, you can always come back to court. And from here on out, everything you do, you need to ask yourself 2 questions. Could this potentially result in me being revoked and you're looking up 20 years in prison? If the answer is yes, don't do it. If the answer is maybe, don't do it. Because guess what? When you bring the newborn baby home, that time passes by so quickly. And if you end up going to prison on this, by the time you come out, if that's what ends up happening, that child is not going to know you. And there may be some other man, because people know no loyalty to wait for you. It's not like a Lifetime movie where they're waiting for you to get out of prison. You understand?
Yes, ma'am.
And I see that one of the cases that this is running concurrently with is a gun case. Again, you're going to have a little baby running around. You're not allowed to have weapons because you're on probation.
Mhm.
You understand?
Yes, ma'am.
And if you ever get to that point where you're allowed to have weapons, you need to make sure those weapons are secure because children are curious and they will find things. You understand?
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you.
You're welcome. And thank you for dressing appropriately.
Thank you.
Judge, may we be excused to go to County Court 9 and then come back up here to see probation?
Just let probation.
This defendant thought a cruise would fix his life. Instead, it almost sank his freedom. He was already on deferred probation for a drug case, ordered not to leave the county, and had a protective order saying stay away from a specific person. So what does he do? He books a cruise with that same person. At the port, passport check hits the system, officers see the protective order, and he's pulled off the ship. No cruise, no refund, and now he's back in front of the judge. Would you risk prison for one vacation? Was this love or just reckless? Tell me in the comments what you think. And if you want more real courtroom breakdowns, hit like, share this video, and subscribe for the next case.
No, I always want to get names correct. So I always tell people when they come before me, if I'm mispronouncing your name, let me know. Because
Yes, ma'am.
once the mispronunciation is in my mind, it's in there. Yeah.
Like mine.
All right. So my understanding, there were CPS records.
No, there's a drug case.
No, this is a forgery case,
Yes.
but for some reason, I think somebody said that there was prior CPS history or something.
That I don't know because I'm only dealing with a forgery case.
Yeah, no, there's let me look on the record. Just one second. Let me find what page she is on.
Let's see.
All right, thank you. Do you have any children?
Yes, ma'am, I do.
Is there a CPS case out there?
Yes, ma'am, it is.
See, that's why I wrote that down. So, state, they're probably gonna need CPS records. And I know that's family violence, but, there may be a CPS case related to this, the drug issue.
No, well, I say no. There's no lab test on the drugs.
No, no, I understand that, but here's the thing.
Okay.
I'm telling you all that my experience on the CPS side, whether they closed the case or kept the case open, these charges are probably why there was a CPS case open or is there. If y'all don't want, here's the thing, if y'all don't want CPS records, guess what? We will go on the record now and everybody can agree that they don't want CPS records. And if y'all say you don't want CPS records, when we go to trial, there will be none of this, oh, we need CPS records.
We want them.
Okay. So, State, if you can check family violence about the CPS records, I know it's a,
I'll send them a link for how to do, or I'll talk to their advocates so they can get that ball.
oh, thank you. All right,
And then
so,
can I tell you why I actually approached?
yes,
Because it had nothing to do with CPS, because I didn't know about CPS.
all right, CPS records, yes.
The state has the forgery case.
Mhm.
That file. They do not have the file on the drug case. It's not indicted.
No, I'm aware there are
I know
two,
you know.
yeah, there are two drug cases that have not been indicted. There's a possession less than a gram and there's a 4 grams to 200 grams. State, do you have any idea when those cases will be indicted? Okay,
Sorry, Judge,
or where they are in the system as far as labs?
I can check.
Do we know what the offense date is?
I know the
It looks like there's.
March 26, 24 is the offense date for the undergram and a misdemeanor theft.
All right.
Now, For the forgery, the office date is 2023.
All right, and then I see for the 4 to 200 grams, it's May 2024. So what we're gonna do then, Norma? Recall this for 60 days. That's to see if the labs are in.
Thank you, Your Honor.
All right, could I have a file stamp for motion to revoke, please? Thank you, no problem. And counsel, would you introduce yourself to the court reporter?
Raymond Martinez.
Court is calling 2018 CR 0164, State of Texas versus Reginald Hunter. Can I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense?
Raymond Martinez.
Are you Mr. Hunter?
Yes, ma'am, I am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did, ma'am.
Are you the same Reginald Hunter who's placed on community supervision in 2018 CR 0164 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on August 3rd, 2021 for a term of 5 years? Is that you?
Yes, ma'am, it is.
State?
Violating condition number 5 in Bear County, Texas. The defendant Reginald Marriott Hunter did then and there failed to report to the supervision officer as directed on September 25th, 2023.
How do you plead to that? True or not true?
True.
State?
Revoke supervision.
No. Do you waive?
Waive and abandon the remaining allegations, Your Honor.
All right. Any objection to the waiver?
No, Your Honor.
All right. Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty? I'm sorry. Well, you're already guilty, but did you understand the court could find it true and sentence you up to 8 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Judge, can I jump in here for a second?
Yes.
We thought the underlying was 5.
No, it's 8.
And my client, I need to have another conversation.
All right.
Because I misspoke. I told him it was 5.
Okay, no problem.
So we'll pick up where we left off. That just 1 second.
Sure.
Judge. Okay, Judge.
All right, we're back on the record. Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, sentence you up to 8 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor.
And what is that proposed agreement?
It's 5 years to do, Judge.
All right, so you all are requesting revocation in 5 years?
Yes, Your Honor.
Any objection to the court reviewing the court summary?
No, Your Honor.
Hunter, I'm reviewing the court summary. And it appears that you don't want any help. There's nothing left to be done for you. You've been placed in inpatient facilities, you've been in sober living homes, and then once you maintain your sobriety for a while at the sober home, then you go back to your last residence and you just start using, you fall off and you don't do anything. This is not your first motion to revoke. Probation, what are you requesting?
Judge, if not revocation, safety is after followed by supervision for the remainder of probation. Judge, in reviewing this case, I see that there was a condition for evaluation felony report, but I don't think that was one every time.
Well, the problem is felony drug court, there's no room at the end.
I'm sorry.
Felony drug court, they don't have room to accept anyone else.
So, Judge, if not revocation, then
I just don't think you're a good candidate. We've tried everything.
Well, and this is kind of, he understands that, Judge, and that's why he's agreed to the revocation. I can tell you, Judge, and he can tell it probably better than I can, that it's not that he didn't get anything out of these programs, and as you can see, he did DDRF as well, and SATIF, and lifetime recovery, so he's done quite a few things. Not too long ago, he lost a parent, and maybe it's part of him turning the page. He knows what he needs to do to stop, because he's, like you said, he's been through all the programs. And either he's going to or he's not, but he's not going to take up the court's time anymore, and he's going to respectfully ask the court for credit for programs he did complete in terms of his past credit, and start out his sentence until he's paroled.
All right. All right, the court will grant the motion, revoke, sentence you to 5 years in the prison, give you credit for any time served. Probation, do you know if he paid the restitution to San Antonio for drug testing? Oh, and I'm sorry, state, you may be excused.
Thank you, Your Honor.
No problem.
Yes, that
All right. Mr. Hunter, are you asking the court to follow your proposed agreement?
Yes.
All right, are you waiving your right to appeal?
Yes, I am.
And have you understood everything that has gone on with your case today?
Yes, I did.
All right, the court will follow your agreement. The court is finding violation of condition number 5 true. The court will grant the motion, revoke you, sentence you to 5 years in the prison, give you credit for any time served. I'm going to request the therapeutic community. It doesn't increase the length of time that you're in prison, but they may be able to address your issues. I'll request that in the mental health unit. You'll also have to request it because I have no jurisdiction to force them to place you in the program. Do you understand?
Yes,
If you don't, let me know.
I'm trying to figure out exactly what that was all, what that
All
all
right,
meant.
so the therapeutic community is to help you with any drug issues you may have. And they may have changed a little bit and they may have some more programs to address with you. The reason for the therapeutic community, it's supposed to help you transition once you're released from prison so that you won't be back in another court for the same thing. The mental health unit will be able to help you if you have any mental health issues, and they will do an intake process to see what they need. For example, if you need to be on medications or if you need to see a mental health therapist, that way, when you're released from prison, you will have everything set up where you won't hopefully be back in a criminal court. Do you understand? Now, I can't force them to place you in a treatment program. All I can do is request it. I don't have any jurisdiction. So if I request it and you don't request it, it will definitely be a no. If I requested it and you request it, it will be a maybe. You understand?
Mhm.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I do.
All right, good luck to you. We can go off the record. You're going to have to start making better decisions. Once you're released from the prison, if you can't find a rehab facility or mental health facility, you can always come back to this court. If I'm here, I will direct you to where you need to go. You understand?
Yes, I do understand what you said.
All right, good luck to you.
This defendant didn't just get one chance. He burned through all of them. After being caught with a large amount of hard drugs, he got probation, inpatient rehab, sober living, lifetime recovery, every program the court could throw at him. Each time he stayed clean for a while, then went right back to the same house, the same streets, and the same addiction, until even the judge said, "We've tried everything," and sent him to prison for 5 years. Did the system fail him, or did he fail himself? Tell me in the comments, and don't forget to like, share, and subscribe for more real courtroom breakdowns.
Trial date.
Yes, Your Honor, we do.
And this is gonna go.
Yeah,
All
absolutely.
right, all right.
Yeah,
And I know we couldn't go last time because we were in a jury trial. We're always in a jury trial.
they can move.
All right, Ms. Ferguson, I need a jury trial date on this case. How long do y'all expect it to last?
No longer than a week, maybe 3 or 4 days.
Yeah, I think 3 days.
All right,
Four at the very
At the
most.
most.
all right, it's probably 3 days. I've seen both of them in trial, so it'll be 3 days.
I like to go real slow.
All right, you're gonna go to trial on October 8th.
I'll be out of town that day.
Where are you gonna be?
California.
California,
Doing
Your
what?
Honor, Bear County's with a B, California's with a C.
Thank you.
I have to-
Well, what city?
San Diego, visiting my sister.
What county?
I don't know what county she
All right,
is.
does your sister even really want to see you? Sometimes sisters are like, I have brothers, so I know. All
She said
right,
She did.
all right, we
I don't
can't,
ask a follow-up question. I'm saying
okay,
yes.
we can't interfere with that. All right,
District Attorney, what is your name?
Matthew Allen.
all right, so Norma, we'll need a different date because he's visiting his sister and he better move furniture or whatever else she needs done.
We're supposed to go to Disney.
Oh my gosh, I would probably be saving him. They tell me the lines are long.
Oh, yeah.
We
Yes.
can do, it is, I don't like to interfere with people's ability to vote. Yeah, Norma,
I think we're double digits already.
well, I don't want to have a case tried on election day. I don't like to interfere with people's inability to vote, whether I'm on the ballot or not. What if we were to do, maybe if we did jury selection? Deputy Laura's looking at me. But Sean, are you gonna look at me?
Oh. I
So you guys say this case will take 3 days, correct?
think that's a very fair guess.
So if we, Norma, if we were to do jury selection. Norma, what do we have? If we were to do it the week of November 11th, I know November 11th is a holiday.
Actually, Sid Arnold said that day, Judge.
Okay,
I had to move him because he's in the lower trial. And another count,
and what is he trying?
a murder. So I had to move.
No, I mean, what is he trying in this
Oh,
court?
in this court, it's a,
Is it a sex case?
yes.
You know what? Go ahead and put them for the 12th. I'll see if there would be another courtroom available for him. And if there's not another courtroom available for him, then you won't be going on the 12th. But that's the only other option I would have, and you all tell me how this sounds before you put it in stone, Norma, would be to do a jury selection on Friday, November 1st. And then we would take testimony on Monday. We would have the 5th off because I don't want to interfere with jurors voting on election day or anybody voting on election day. And we could come back and finish it on the 6th. Actually, that sounds better to me. Norma, can we do that?
Yeah.
All right, so we're going to do jury selection on November 1st. Are you all okay with that?
Yes, Judge.
I'm thinking election, I'm thinking like last day of early voting. I'm good with whatever the court wants, Your Honor, absolutely, but I'm just thinking people usually run out to the polls, so they don't have to go on voting day. That would be the last day of early voting.
Oh, but I anticipate we'll do jury selection in the morning, so they'll still have all afternoon.
Just the selection on
Yeah,
that
we're
day.
not doing,
Understood.
Yes.
Okay, yeah.
all right, so we'll put you down for November 1st, even though it's interfering with my birthday celebrations, but okay.
Well, you get to spend your birthday with me.
Yeah, Okay.
Oh, that's no Disney.
Yeah. First my sister, now judge.
No, it'll be great city. Well, that's okay because I celebrate the entire month of November, so we're fine. And November 1st is not my actual birthday, so. All right, we'll put you down for November 1st. That will be jury selection only. And then November 4th, testimony, 5th, nothing, because I'm gonna give everybody a chance to go do their civic duty. And then we'll come back up on the 6th and hopefully it will be done.
Okay.
All right, anything else?
No, nothing from the state, Your Honor.
All right, once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome.
Kid has checked multiple times.
Everyone, please whisper.
I'm not sure what exactly to do. She's checked for this file. She cannot find that physical file, Your Honor.
Oh, you all are gonna have to make a duplicate or recreate your file.
We have.
Yep,
So when are you all gonna be able to do that?
that would probably take a couple weeks, but we can get the process started today.
All right.
Again, the last time it was the first time we had kind of not been able to find it, so today I think it's kind of time to.
All right, and I'm assuming this protective order is for CPS records?
That's for CPS records, physical records only, not to subpoena a person. I've already reached out to the regional attorney, Marilyn Bradley. She gave me this protective order. And if I do have discretion, I had her permission where it says excluding any audio video in their possession. If you could actually put including, if they have it. But if you could scratch out excluding and put including.
All right, so we're gonna go on the record. And before we do that, have you had a chance to review the protective order that was prepared by the regional attorney?
Council briefly discussed it with me, Your Honor.
All right, we're gonna go on the record. In 2000, well, let me ask you this before we do that. Are you also representing Refugio Rodriguez?
Monica Gadetto, there's a Danielle Cranberg who's covering that.
Come forward. Oh, and introduce yourself to the court reporter. Thank you. All right, is there, before we go on the record, is there Mr. Refugio Rodriguez? Is there the same issue with the file on missing in this case?
We have that file and we've given them a copy of the CPS records. They're gonna do the forensics. So in that one, we're making definite progress. This one is a little bit different.
All right, so let's do this. Let me take up the easy case first, and then Mr. Stetson, I'll take you up to 24 CR 2911, State of Texas versus Lucy Rodriguez. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Joseph Stateson.
And are you Miss Rodriguez?
Yes, ma'am.
All right, so off the record, state, you informed the court that you have been unable to find her file?
Yes, Your Honor.
All right, so state, you're gonna have to,
Create a duplicate. Yes, Your
Yes.
Honor. We will,
and how long are you saying that will take?
a few weeks, Your Honor.
All right. And then defense counsel has submitted to the court a protective order prepared by the regional attorney Marilyn Bradley. And counsel, I know you asked for the court to change the language where it says the producing party is ordered to release all records excluding audio and video records.
Mhm.
With regards to the audio and video records being released to you, it sort of depends on what it is. So I don't feel comfortable saying excluding that, but if you will let her know if she's aware of, or they have audio and video records to release them. And if they're saying, no, we can't release those, I can do an in-camera inspection to see if they should be released. Do you have any objections to that? I'm sure you do.
If the records are not in their custody, they have no obligation to turn them over. If they're in their custody, I would like them in.
All right. And so this is the court's ruling on that. I'm not going to order them to release the records over the objection of the state without a hearing.
Regarding audio, video only.
Yes, regarding audio and video only.
Yes, Judge.
And the reason why I'm doing that is because I don't know what the audio video is of, and sometimes CPS, their audio and video are things that legally, according to the code, can't be turned over. And I won't know that unless you all have seen it. So I have no idea if it is or not. All right, so what date do you want these documents by? It should be fairly simple because the state already has them.
Prior to today, I wasn't aware that they had the CPS records available for defense counsel in the other case. So I had done this on my own.
Okay.
I know that sometimes there's a difference between redacted and unredacted. I don't know if any of those records are redacted or not. But if I could have this, the deadline would be, if it's 30 days to come back, I would like it to have at least, 7 to 10 days before the deadline for the next
Well,
setting.
or if you would like to do this, because it appears that these cases are somehow related. I'm assuming that they're related. And that the gentleman who was just up here, they already have CPS records. So I don't know if you want to review those CPS records and then you can come back with more of a detailed
I would,
order or not. It's
I
up to you.
would prefer to have that protective order signed and presented to DFPS.
Okay. All right, Ms. Ferguson, what date do you want to bring this back on?
You want to bring it back the same day as the other one?
Sure.
Imagine walking into court on serious CPS-related charges, and the prosecutor shrugs and says, "We can't find your file." The judge isn't having it. She orders the state to rebuild the entire case from scratch, forces a new protective order for CPS records, and even warns she might personally review any secret audio or video before deciding if the defense can see it. One missing file just turned into a high-stakes battle over evidence and transparency. What do you think? Is this just sloppy work, or does it feel suspicious? Let me know in the comments, and don't forget to like, share, and subscribe for more real courtroom breakdowns.